Supreme Court just handed down a ruling on ghost guns that the mainstream media is completely misrepresenting. If you own an 80% lower, if you've built a firearm at home, or if you're thinking about building one, what the media isn't telling you could be the difference between staying legal and facing federal felony charges. Hit that subscribe button right now. The Supreme Court's decision on privately made firearms affects millions of gun owners, and media coverage is designed to make you think the ruling means something completely different from what it actually says. Here's what happened. The Supreme Court issued a decision on the ATF's regulatory authority over unserialized firearms and unfinished receiver blanks. The case challenged whether the ATF exceeded its authority when it created new rules requiring serial numbers and background checks for 80% lowers and build kits. The court's ruling is not what either side wanted. Let me break down exactly what the Supreme Court said, what the ATF's new rules actually require, what the media is lying about, and most importantly, what you need to do right now if you own or are building firearms at home. Number one, what ghost guns actually are. The media uses this term to scare people. The legal term is privately made firearms or PMFs. A privately made firearm is any firearm manufactured by an individual for personal use without a serial number. This includes firearms built from 80% lowers, also called unfinished receivers. An 80% lower is metal or polymer, roughly 80% complete, but not legally a firearm yet, because it can't function without additional machining. Building your own firearms has been legal in America since before America existed. The Founding Fathers built their own guns. This is not some new loophole. It's a fundamental right predating the Second Amendment. The issue reaching the Supreme Court was the ATF's attempt to redefine what counts as a firearm under federal law. In 2022, the ATF issued a final rule changing how they classify receiver blanks. Under the new rule, items readily convertible to function as receivers are now classified as firearms. Readily convertible means convertible with basic tools and minimal effort. But how do you define basic tools or minimal effort? The vagueness is intentional, giving the ATF maximum enforcement discretion. If you're finding this helpful, imagine what you'll learn in my next video where I break down the exact legal definition of what counts as a firearm under the new ATF rule. Subscribe right now because that video includes step-by-step guidance on staying compliant. Number two, here's what the Supreme Court actually ruled, and this is where the media is being dishonest. The Supreme Court did not uphold a ban on ghost guns. They did not rule that building firearms at home is illegal. What they actually did was much narrower and much more technical. The court ruled on whether the ATF has the statutory authority under the Gun Control Act to regulate unfinished receivers and frames as firearms. The Gun Control Act defines a firearm as any weapon which will or is designed to expel a projectile by the action of an explosive or the frame or receiver of such weapon. The question was whether an unfinished receiver that cannot function as a receiver yet counts as the frame or receiver of such weapon under the statute. The ATF argued yes, if it's readily convertible. The challengers argued no, because Congress defined firearms based on function, not on potential future function. The Supreme Court's ruling held that the ATF's interpretation of readily convertible is within their regulatory authority as long as it's not arbitrary and capricious. This doesn't mean the ATF can do whatever they want. It means courts will defer to the ATF's technical expertise when interpreting ambiguous statutory language, but the ATF still has to act reasonably. Here's what the media won't tell you. The court did not say all 80% lowers are now illegal. The court did not say you can't build firearms at home anymore. What the court said is that the ATF can regulate items that are readily convertible to function as firearms, and courts should defer to ATF's technical determination of what's readily convertible. This creates a gray area. Some 80% lowers might be readily convertible under the ATF's definition. Others might not be. Some build kits with jigs and drill templates might push items into the readily convertible category. Others might not. The specifics matter enormously. Quick legal note. This is educational information about Supreme Court decisions and ATF firearms regulations. This is not legal advice for your specific situation. If you own unfinished receivers, if you've built firearms at home, or if you're facing charges related to PMFs, you must immediately consult with an attorney who specializes in federal firearms law. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these Supreme Court updates first. Click that subscribe button because next week I'm covering which specific 80% lower designs are most at risk under the new ATF interpretation. Number three, what the ATF's rule actually requires. The ATF's 2022 final rule on privately made firearms imposes several requirements. First, if you sell or transfer a PMF, you must serialize it and run the buyer through background check. You can't sell unserialized PMFs anymore. Built a gun 5 years ago and want to sell it? Must have serial number added by licensed gunsmith first. Second, dealers or manufacturers selling unfinished receivers or build kits must treat them as firearms if readily convertible. That means NICS checks, bound book records, all FFL requirements. Days of buying 80% lowers online for direct shipping are over for items falling under this definition. Third, if you already own unserialized PMFs, you're grandfathered for personal possession. No need to serialize guns already built for yourself. But to sell or transfer, must serialize first. Fourth, gunsmiths serializing firearms must comply with specific engraving requirements, certain depth, size, location. DIY hand engraving not meeting technical specs doesn't count as properly serialized. Where people get in trouble, thinking they can continue building 80% lowers and selling privately without serial numbers. Wrong. Manufacturing firearms with intent to sell requires manufacturers FFL. Build for personal use, then decide to sell, must serialize first. Ignore these rules? Federal felonies. Number 4, what the media is deliberately hiding. Mainstream media coverage has been almost universally dishonest. Headlines scream Supreme Court upholds ghost gun ban or court rules against homemade firearms. Both are lies. The court did not uphold a ban because there is no ban. Building firearms at home for personal use is still legal. What changed is the regulatory framework for what counts as a firearm requiring serialization. The media wants you to think the Supreme Court banned ghost guns because it fits their narrative. But the court simply said the ATF can regulate items readily convertible to function as receivers. Much narrower and more technical. Why the media lies? If they reported accurately that home manufacturing is still legal, their ghost gun epidemic narrative falls apart. Accuracy doesn't drive clicks and doesn't serve gun control agenda. What the media won't tell you, this ruling actually preserves some gun owner rights. The court could have held the ATF has unlimited authority. They didn't. They said authority is limited to readily convertible items, meaning there's still a line the ATF can't cross. This information could save you from federal prison. Subscribe now because my next video reveals the exact compliance steps you need to take if you own 80% lowers or PMFs right now. Number 5, let's talk about what you need to do right now if you own or are building privately made firearms. The Supreme Court's ruling doesn't change the law overnight, but it clarifies that the ATF's 2022 rule is enforceable. Action Step 1. If you own unserialized privately made firearms for personal use, you can keep them. You're grandfathered in. But do not sell or transfer them without first having them properly serialized by a licensed manufacturer or gunsmith. The serialization must meet ATF technical specifications. Don't try to DIY this with a handheld engraver unless you know exactly what you're doing. Action Step 2. If you are planning to build a firearm from an 80% lower or unfinished frame, understand that the regulatory landscape has changed. Some 80% lowers may now be classified as firearms under the readily convertible standard, which means you'd need to purchase them through an FFL with a background check. Check with the seller to understand how they're classifying the item under the new ATF rule. Action Step 3. If you're a dealer or manufacturer selling unfinished receivers or build kits, make sure you're complying with the ATF's 2022 final rule. If the items you're selling meet the readily convertible definition, you must treat them as firearms. That means NICS checks, bound book entries, and all FFL compliance requirements. If you're not sure whether your products fall under the new rule, consult with an attorney who specializes in firearms manufacturing law. Action Step 4. If you've sold PMFs in the past without serializing them, understand that those transactions may now be scrutinized. Don't make any statements to law enforcement about past sales without an attorney present. The statute of limitations for federal firearms violations is typically 5 years, which means sales from recent years could still be prosecuted. Action Step 5. Stay informed about ongoing legal challenges. The Supreme Court's ruling is not the final word on this issue. Gun rights organizations are bringing other challenges to the ATF's rule on different legal grounds. Watch for developments in those cases. Action Step 6. If you're facing charges related to unserialized firearms or 80% lowers, immediately hire an attorney who specializes in federal firearms law. Do not talk to law enforcement without counsel. Do not try to explain yourself. Anything you say will be used against you. Get professional legal representation. Here's the bottom line. The Supreme Court ruled that the ATF has authority to regulate unfinished receivers and frames that are readily convertible to function as firearms. This is not a ban on ghost guns. This is not a ban on home firearm manufacturing. This is a regulatory decision about what counts as a firearm under federal law. Building firearms at home for personal use remains legal, but if you want to sell or transfer those firearms, they must be serialized. If you want to buy an 80% lower, it might now require going through an FFL and background check depending on whether it meets the readily convertible standard. The media is lying about what this ruling means because accurate reporting doesn't serve their agenda. They want you scared and confused. They want you to think your rights are disappearing. But the reality is more nuanced. Some regulatory ground was lost, but home manufacturing is not illegal. For gun owners, the key is understanding the new rules and complying with them. If you own unserialized PMFs, keep them for personal use or serialize them before transfer. If you're building new firearms, understand which components now require FFL transfers. If you're manufacturing for sale, make sure you have the proper license. The ATF's enforcement has been inconsistent. Some jurisdictions are aggressively prosecuting PMF cases. Others are barely enforcing. But don't gamble on non-enforcement. The penalties for federal firearms violations are severe, up to 10 years in prison for unlicensed manufacturing or dealing. Look, I spend hours every week reading Supreme Court decisions, analyzing ATF regulations, and breaking down media lies so you understand what's actually happening versus what you're being told. The least you can do is hit that subscribe button to make sure you never miss an update. Subscribe right now. Share this video with every gun owner you know who might own 80% lowers or PMFs. The media wants them confused and scared. We're giving them accurate information. Remember, this is educational information about Supreme Court decisions and ATF regulations. It is not legal advice. Always consult with a qualified attorney for your specific legal situation. Stay informed, stay legal, and don't believe the media's lies about ghost gun bans. Thanks for watching. I'll see you in the next one, where we analyze which 80% lower designs are most at risk under the ATF's readily convertible standard.